Good morning and welcome to part one of Landmark Chambers High Court Planning Seminar, which is part of our webinar series. We're delighted that so many of you are joining us at today's session, and we hope that you'll find the presentations and discussions to be useful and informative. My name is Dan Kolinsky and I'm chairing today's session, and I'm joined by my colleagues Richard Turney, Andrew Byass, Heather Sargent and Joel Semakula, who I will formally introduce in a moment. Before we begin, just a few points of housekeeping to note. Your microphones are going to be automatically muted, so there's no need to be concerned about your local settings. We very much welcome questions throughout the session. We would invite you, please, to submit them via the text in the Q&A section, which you'll find either at the top or bottom of your screen. Within that, there's an option to submit the question anonymously if you prefer to do so. So please feel free to click send anonymously if that's your preference before submitting your question. We'll endeavour to pick up and answer as many of the questions as possible at the end of the presentations. This webinar will be recorded, and you should receive a link to the presentations and the recording shortly after the event concludes. If for any reason your connection is lost at any point during the webinar, please don't worry, you can just click back in and rejoin please just go back to the original link and try once again. So that's the end of the housekeeping. I'm going to introduce all of our speakers in one go, and then we're going to hear from them. Actually, I'm going to be introducing them in order of their call, and as it happens, it's in reverse order. So if I could introduce Richard Turney, first of all. So Richard Turney specialises in planning, public and environmental law. He's a member of the Attorney General's A panel, and he regularly appears in the High Court and Appellate Courts in planning challenges. He has particular experience in infrastructure work, having acted in the very first challenge to a DCO under the 2008 Act, and most recently acted for Heathrow in the Supreme Court last year. He regularly appears at the DCO examinations, including Hornsea 3 offshore wind farm and the A303 Stonehenge scheme. And so Richard, as indicated, will be speaking on the Planning Act 2008 challenges during the last year. The next speaker I'd like to introduce is Andrew Byass. Andrew has a broad planning and public law practice. In recent years, he's been heavily involved in infrastructure policy developments and challenges, acting for the DFT in the preparation of the airport's NPS and in the challenge to the NPS once it's made. Also acting for the DFT in challenges to alleged unlawful failures to review and suspend National Networks NPS. And Andrew acted for Herefordshire Council in the Smolas case, and on Friday, much to his relief, he finished a 5-week inquiry in Tunbridge Wells, acting for Natural England. Thirdly, I'd like to introduce Heather Sargent. Heather was ranked as the top planning junior barrister under 35 and one of the top 5 juniors overall in this year's Planning Magazine Planning Law Survey. Her experience is wide and various. She acts for both developers and local planning authorities, including on several central London tall building schemes. She regularly appears for site promoters at local plan examinations. She's acted as sole counsel for an acquiring authority in a substantial CPO road scheme, and has advised Gatwick Airport on proposed DCO to bring its existing standby runway into routine use, and has extensive experience on the side of appellants and local authorities in relation to a range of major housing schemes. And our first speaker, Joel Semakula, is one of our newer tenants, and he specialises in planning, property, public and environmental. He had the good fortune to be a pupil of Richard Turney, and in the context of that was involved and saw firsthand some of the Heathrow and Friends of Earth challenge at Court of Appeal level, and he's building a planning practice with planning clients, including local authorities and individuals, as well as giving pro bono assistance via the Environmental Law Foundation. And Joel is our first speaker. I'm going to invite him to start, and he's going to talk to us on where are we on climate change grounds after Heathrow and Friends of Earth. Joel, over to you.
Okay, good morning, everybody. So I'm here to start with Heathrow and Friends of the Earth, a case that will be well known to many of us on this webinar. So first beginning with some of the background in that case, many of us remember the policy decision there under challenge was an airport's national policy statement. And an NPS sets the fundamental framework within which further planning decisions will be taken. There, the ANPS under challenge was made in 2018 by then Secretary of State Chris Grayling, after many years of commissions and debates about airport expansion. And of course, around this time, the other major player in this litigation was the Paris Agreement, concluded in December 2015 and ratified by the UK government in November 2016. And the Paris Agreement commits parties to restrict temperature rises to well below 2 degrees Celsius above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 degrees Celsius above pre-industrial levels. Now, in February 2020, and indeed while I was sitting with Richard Turney, the Court of Appeal declared the ANPS unlawful because the Secretary of State had failed to take account of the Paris Agreement. Interestingly, the Secretary of State did not appeal the Court of Appeal's decision, but Heathrow Airport did, on the ground that it had significantly invested in the new scheme and wished to seek development consent. Now, the UK's domestic climate change legislation derives from the Climate Change Act 2008, and the Planning Act 2008, setting out the NPS system, required government in a given national policy statement first to explain how it takes account of policy on climate change, that being section 5.8, and second, to exercise its NPS functions with regard to the desirability of mitigating and adapting to climate change, that being section 10. So when this case got to the Supreme Court, the challenges debated there revolved around these two sections of the Planning Act 2008, and then claims that the Secretary of State had failed to take into account long-term post-2050 and non-CO2 emissions. There was also a debate there about the impact of the SEA directive, which I won't go into here. Now, on the first ground there, all in the Supreme Court agreed that the UK's ratification of the Paris Agreement did not amount itself as government policy. This was an act on the international plane and gave rise to no legal rights or obligations in domestic law. So all that kind of so far so good when we're looking at section 5.8. And then further, the court held that the Secretary of State took into account his duties under the Climate Change Act, and hence it was said the Paris Agreement. It was said gave weight to that agreement, and to the extent that its obligations were covered by measures taken under the Climate Change Act, ensured that those obligations would be brought into account when decisions were taken pursuant to the framework set by the Airport National Policy Statement, that being via the DCO process. And there the court identified the remaining question to be whether the Secretary of State acted irrationally in omitting to take the Paris Agreement further into account. Now, unsurprisingly, once the question was framed in that way as one of irrationality, the court found there had been none. And in effect, on the facts, the Supreme Court determined that he had indeed taken the Paris Agreement into account and lawfully exercised his discretion as to how much weight to attribute to it. Now, of particular interest for those bringing climate change grounds of challenge, the Supreme Court there decided in that case that the Paris Agreement was not an obviously material planning consideration regarding a planning decision in relation to an airport. And what that means is the Secretary of State, and we're going to see what this means on a wider basis, had a discretion as to whether indeed to take it into account. And just to close this out, the Supreme Court also here rejected the third ground and accepted the Secretary of State had not acted irrationally in not taking into account the post-2050 emissions, given the difficulty in assessing these. And that quantification uncertainty, the court found the same thing in respect of aircraft emitting nitrogen oxides, water vapor, and some of the other emissions raised as part of that challenge. So moving on, so once we start there at Heathrow, well, what does that mean and challenges that have come since this case? The next case I want to talk about is Peckham and Secretary of State for Transport. It's a case in the Court of Appeal. And it was a challenge brought by an environmental campaigner who applied for permission to appeal against the refusal of permission to seek judicial review of the government's decision to continue with the construction of HS2. Now, in 2019, there was a review commission, the Oka v review, to consider whether and how to continue with this particular project. The review report there, published in February 2020, indicated that the project should continue with qualification to reduce carbon emissions and other mitigating measures. In February 2020, the government adopted the decision under challenge to continue with the project. Now, following the initial refusal of permission there, the applicant maintained that by continuing the project, the government had erred in law by disregarding local environmental concerns, and that the Secretary of State had failed to take account of the project's effect on greenhouse gas emissions in light, again, of the Paris Agreement and the Climate Change Act. Now, in refusing permission, the Court of Appeal held that the government did not fail to consider these implications of the Paris Agreement and the Climate Change Act in the decision to proceed. There, the court held that the statutory and policy arrangements for achieving net zero by 2050 were said, and I quote, to leave the government a good deal of latitude in the action it takes to attain these objectives, and likely increases in emissions resulting from the construction and operation of major new infrastructure are considered under that strategy. But it is the role of government to determine how best to make that transition. And you're going to see this kind of deference to the decision-making government there as we continue to work our way through the challenges that have been brought since Heathrow. Now, moving on to roads, the next case I want to talk about is Transport Action Network. This case was in the High Court. Transport campaigning, this campaign group applied for judicial review of the Secretary of State's decision to set the road investment strategy for the period of 2020 to 2025, pursuant to the Infrastructure Act 2015, Part 1, Section 3.1. The court here refused an application for judicial review of the decision. Now, in applying the Heathrow case, the court here held that the Supreme Court had decided that the Paris Agreement was not an obviously material consideration regarding a planning decision in relation to an airport. And so the Secretary of State had a discretion as to whether to take it into account. And there was no reason for reaching a different conclusion in the context of the 2015 Act and the setting of this strategy. The 2015 Act itself required the Secretary of State, when setting an investment strategy, to have regard to the effect on the environment without any specific reference to climate change. And in any event, as a matter of fact, the court there found the Secretary of State had taken sufficient account of net zero emissions target for the UK in 2050 contained in the Climate Change Act in Section 1 there, and the UK's carbon budget set under Section 4 of the same Act. And now a more recent case, the Klein Earth case in which that particular charity appealed against the dismissal of its claim for judicial review of the Secretary of State's decision to grant a development consent order for a nationally significant infrastructure project. So this case had gone through the DCO process, and interestingly, in that case, the examining authority had recommended that development consent be withheld. That authority had concluded that although the overarching national policy statement for energy, the EN1, and the national policy statement for fossil fuel electricity generating infrastructure, EN2, supported a need for additional energy infrastructure in general, the power station here had not demonstrated that development would itself meet an identified need for gas generation capacity. The examination authority there also concluded that the increase in greenhouse gas emissions was likely to be higher than the power station had estimated and would undermine the government's commitment to cutting emissions. Now, in going against the recommendation, the Secretary of State there accepted that development would have significant adverse environmental impacts, but concluded that it would meet a national need for carbon capture ready fossil fuel generation as set out in the first policy statement, which outweighed those impacts. So in terms of grounds of challenge here, the issue for the court there was the proper interpretation of that policy statement, EN1. And for our purposes, again, and returning to the issue of deference, it's that second part that is particularly important, namely that the court there determined that the weight to give to greenhouse gas emissions impact is a matter for the decision maker. And so the Secretary of State was entitled to regard it as not being determinative in the balancing act exercise. Those were matters of planning judgment, and there was no single prescribed way of performing that task. And then another challenge here we had in the High Court, the Abbott's Kurzweil Parish Council case, which I'll mention briefly because we're going to hear a bit more about it in the next presentation. Now, in that case, the Parish Council had applied for statutory review of the Secretary of State's decision to grant the application for outline planning permission for a major mixed-use development. The development there was site was near a special area of conservation where a significant proportion of European protected species was contained. The Secretary of State there granted planning permission. I think the local authority there had failed to determine the application in time. And he held that the environmental statement and other documentation provided in support of the application contained sufficient information for him to assess the environmental impact of the proposed development. Now, I'm focusing just purely on the climate change ground here. Now, in refusing the application for judicial review on the basis of greenhouse gas emissions and on that climate change ground, the court there held that the climate change was a matter falling within the EIA regulations, and it followed, pursuant to the definition of environmental statement in Regulation 2 of those regulations, that the Secretary of State was only required to consider the adequacy of such information on climate change in the environmental statement as might reasonably be required. Now, in deciding what information was reasonably required, he had a wide range of autonomous judgment on the adequacy of the information provided and had to be free to form his own reasonable view on the nature and amount of information required. And that was only subject to review on Wednesbury grounds. In that case, the Secretary of State had reached a judgment that the information provided in that statement was sufficient. And he'd also considered the Parish Council's criticisms about the adequacy of information on climate change, and he rejected them. The court found, unsurprisingly, he was entitled to reach those conclusions. In that case, the court held the greenhouse gas emissions had been considered in the context of the local plan, the sustainability appraisal, and the strategic environmental assessment. And it had been decided, following review all those things, that the site should be allocated for a mixed-use development. Overall, the court then determined that the Secretary of State had indeed acted rationally. And now looking at the case of Elliott Smith, another High Court case here where the claimant had applied for judicial review of the legality of the defendant's joint decision here to create the UK emissions trading scheme, which is a replacement for the UK's participation in the European-wide emissions trading scheme. Now, under the new scheme, a cap was set on the total amount of certain greenhouse gases that could be emitted by sectors of the economy over a given period. And that cap was then divided into allowances. Those required to participate in the scheme were either given allowances or had to purchase them to cover the emissions which their activities generated. The allowances could be sold, would be sold through auctions and could be traded. The scheme set an auction reserve price, and over time, that particular cap would be reduced. In terms of grounds here, the claimant there argued that in approving the UK ETS with the cap and auction reserve price proposed, the defendants had failed to have regard to a material consideration, namely the requirement in Articles 2 and 4.1 of the Paris Agreement on climate change to take urgent action to limit greenhouse gases. And the second ground was that the UK ETS did not fulfill or serve the statutory purpose under the Climate Change Act, given in Section 44 of limiting or encouraging the limitation of activities causing or contributing to greenhouse gas emissions. That application, again, in a theme that's running through my presentation, was refused. In respect of that first ground, although there was no express reference to the Paris Agreement in the defendant's decision, the need to take action urgently and in the short term had been acknowledged and taken into account in their approach and the setting up of the UK trading scheme. The court there found that the defendant's approach had been tenable and entirely appropriate, and each of the defendants had been fully aware of the Paris Agreement as understood in that way, and it had taken it into account in reaching, or they had taken it into account in reaching their decision. In respect to the second ground here, the court found that a trading scheme within the definition provided by Section 44 of the Climate Change Act did not necessarily have to achieve a reduction in the activities consisting of greenhouse gas emissions or causing or contributing to such emissions. It was sufficient that the design of the scheme limited or encouraged the limitation of those activities. And now on to my final case here, Finch. Very briefly, in this case, the claimant sought judicial review of the defendant local authority's decision to grant planning permission to retain and expand an existing oil well site and to drill 4 new oil wells for the production of hydrocarbons over a 25-year period. The issue here was whether the developer's obligation under the 2017 regulations to provide an environmental statement describing the likely significant effects of development, both direct and indirect, required an assessment of the greenhouse gas emissions resulting from the use of an end product said to have originated from that development. And unsurprisingly, Mr. Justice Holgate there held that they do not. I know we're going to get a bit more detail about that case in the next presentation, but it's going up to the Court of Appeal. So on that one, what I have to say is watch this space. So I think in conclusion, what we can see is there's been a number of attempts here to bring climate change grounds following the Paris Agreement. And so far, we're yet to see a case that has been successful. First, really showing that there's been a failure to take account of climate change where it was a necessary consideration, or that there's been a failure to take account of it to the scope required by any kind of, by the agreement or any kind of domestic legislation. And so with that, I'd like to hand it back over to Dan.
Thanks very much, Joel. I think from now on, perhaps if each speaker could just hand on to the next one, but I'm very pleased to invite Heather to continue. Thank you.
Thanks, Dan. Good morning, everyone. As you can see from the title page, I'm going to try and give a review of the year in terms of EIA and SEA case law. There have been quite a few cases. I don't have time this morning to go through all of them, so I've just picked the 5 cases that seem to me to be most likely to be of broader relevance to your own cases going forward. And as will be quite obvious by the end of my talk, the recurring theme is, again, climate change. So there is some overlap with the cases that Joel's talked about, but I'm going to focus on the points that we haven't considered. I want to actually look at the Finch case in more detail first, and then do the other 4 cases more rapidly after that. Starting with EIA and picking up Finch, where Joel left us off helpfully. As he said, this is a judicial review of a grant of planning permission for the retention of existing wells and to drill new wells. It is going to the Court of Appeal. Lord Justice Lewison, when he granted permission to appeal, said that although he thought the judges, so Mr. Justice Holgate's reasons for his conclusion were cogent, they were open to proper challenge, and in view of the importance of the question around greenhouse gases, he thought there was a compelling reason for the appeal to be heard. So the main issue is whether the requirement in the 2017 EIA regulations to provide an environmental statement that describes both the direct and the indirect likely significant effects of a development, does that requirement require greenhouse gas emissions to be assessed insofar as those greenhouse gas emissions result from the use or consumption indeed of an end product that's said to have originated from the development? And as Joel explained, the short answer to that question, according to Mr. Justice Holgate, is no, it doesn't. It's interesting to note that right at the outset of his judgment, Mr. Justice Holgate notes the parties' agreement that once the crude oil that's produced from the development that's in question in Finch is transported off-site, of course, it enters an international market, and the refined end product could be used anywhere in the world. So in Mr. Justice Holgate's words, far removed from the Surrey Weald where the site in Finch is. And he also notes, again, I think it's significant that this is right at the start of his judgment, he notes the far-reaching ramifications if the claimant's argument is correct, because it would apply not just to the production of crude oil, but also to the extraction of minerals or to the production of raw materials for use in industrial processes that eventually do lead to the consumption or use of an end product, because generally there are greenhouse gas emissions at each stage of those processes. And the issue might also arise in other industries, such as the waste industry, where again, you can have greenhouse gas emissions generated at each stage. So in short, on the claimant's analysis of the EIA regulations, it would mean that greenhouse gas emissions resulting from the use or consumption of end products emanating from a development would have to be assessed as an indirect of the development. But Mr. Justice Holgate notes as well that greenhouse gas emissions that do eventually result from the consumption or use of an end product actually flow from a number of different contributing sources. So you might have a site for the manufacture of components that contributes, a site for assembly, a site for distribution, and all of those sites and the development on those sites would be contributing to the ultimate greenhouse gases at the point of use or consumption. So as we saw just now, the greenhouse gas emissions in Mr. Justice Holgate's view are addressed by government policy on climate change and energy, and therefore he didn't think it was necessary under the EIA regulations for the local planning authority to go further than, of course, it has to apply those policies in deciding whether or not to grant planning permission, but it's not necessary, in his view, for the local planning authority to go further and to require greenhouse gas emissions to be estimated and then assessed as part of the environmental impact assessment. Both the claimant and Friends of the Earth argued that it was inevitable that oil produced from the well site in Finch would be refined, that it would eventually undergo combustion as an end product, and then that combustion, of course, would produce greenhouse gas emissions. And you can see Mr. Justice Holgate's response there at paragraph 101 of the judgment. He said that the fact that environmental effects might flow inevitably from the use of raw material doesn't provide essentially the correct legal test for working out whether they are to be treated as indirect effects of the development. He goes on to say that, make this point, that an inevitable consequence might occur after a raw material extracted on the relevant site has passed through one or more developments elsewhere, which aren't actually the subject of the application for planning permission, which don't form part of the same project. So in his view, the true legal test is whether the effect is one of the development for which planning permission is sought, rather than something that comes about as a result of raw material having passed potentially through several developments. And again, you can see the emphasis in the bottom bullet point here on indirect effects still having to be effects that the development itself has on the environment. Another of the claimant's main concerns was that if greenhouse gas emissions from the use of an end product weren't required to be assessed in EIA, then the claimant argued that there was no other mechanism by which greenhouse gas emissions could be controlled so as to contribute to achieving the net zero target in the 2008 Climate Change Act. And the claimant relied, and the argument's often made, on Court of Justice case law to argue that a broad and purposive interpretation should be given to the EIA directive. Mr. Justice Holgate says, well, the clearly expressed wording of the legislation can't be disregarded, and so I think this is potentially significant in terms of other cases moving forward. Effect has to be given to that language, even if the result is that some environmental effects are not assessed. He also rejected the proposition that there weren't any other measures in place in the UK for assessing and reducing greenhouse gas emissions, and he referred, amongst other things, to the net zero target in the 2008 Climate Change Act. The claimant argued that UK measures don't, of course, affect the ultimate consumption of oil products by consumers in other countries, but Mr. Justice Holgate gave that argument short shrift. At paragraph 106, he said, whether those issues are thought to be adequately addressed in other countries or even in the UK, can't provide a guide to the interpretation of our domestic legislation on EIA for the consenting of new development. And then you'll see from these two paragraphs, 107 and 112, the point Mr. Justice Holgate is really reiterating here is that development control and the EIA process are concerned with the use of land for developments and the effect of that use. So they're not directed fundamentally at regulating the environmental effects that result from the consumption or use of an end product. Two other points to note from Finch in relation to the EIA legislation more generally. There's some discussion at paragraph 91 to 94 of an argument that failure to comply with the terms of a scoping opinion might itself be a breach of the regulations, and you'll see that Mr. Justice Holgate rejected that suggestion, and he reasons in those paragraphs that just because an environmental statement doesn't comply with the local planning authority's scoping opinion, that doesn't itself amount to a breach of the 2017 regulations. The reasoning for that relates to the specific wording of the provisions within the regulations. And then there's an interesting discussion at paragraph 143 around what is now, I think, paragraph 183 of the NPPF, which is the paragraph that explains that planning policies and decisions are supposed to focus on whether the proposed development is an acceptable use of land and not on the control of processes or emissions, where those are subject to separate pollution control regimes. And as some of you will have come across it several times, it's the paragraph that says that planning decisions should assume that pollution control regimes will operate effectively. And also then paragraph 112 of the minerals PPG is to similar effect and makes the point that planning and other regulatory regimes are separate but complementary. And Mr. Justice Holgate, in relation to those two paragraphs and policies, came to the conclusion that neither of them allows a local planning authority or indeed an environmental statement to disregard a relevant environmental effect, but they do, the complementary regimes of pollution control influence the decision maker's judgment as to the extent to which actually it's necessary to assess a particular effect in the development control process, bearing in mind that there are other dedicated regulatory regimes that are also thinking about it. So that's Finch. The next and the second of the EIA cases that I want to look at is Pierce against Bays. And this is a judicial review of the Secretary of State's decision to make the North Vanguard offshore wind farm DCO. That granted development consent for one of the largest offshore wind farms in the world. And the factual context is that there's a second wind farm project, Byass, immediately to the northeast of the Vanguard project. So NVL were the applicant for the Vanguard DCO, and they proposed that the onshore infrastructure for the two projects should be co-located. So the proposal was that there would be a cable route carrying high voltage current from the landfall for 60 kilometres, and then there would be a substation near a village called Necton. It's also important to note that the environmental, unsurprisingly as you'd expect, the environmental statement prepared by NVL for the Vanguard project did assess the cumulative impacts arising from both of the wind farm projects, including landscape and visual impacts from the onshore infrastructure that was proposed at Necton. But both the examining authority and the Secretary of State decided that actually consideration of cumulative landscape and visual impacts from the two projects together should be deferred to any subsequent examination of the second proposal. So the issue that unsurprisingly raises is whether it's actually lawful to defer consideration of an environmental effect in that way. In short, yes, you can if the decision maker has judged that the effect is not significant. That's the Milne line of case law. But in this case, the decision maker hadn't reached a view that the effect was not significant, so it hadn't been ruled out on that basis. And Mr. Justice Holgate sets out a helpful analysis from paragraph 110 onwards of what he describes as the range or spectrum of situations that may arise where you haven't discounted a cumulative effect as being insignificant. He does caution there that he's not attempting to describe that range or spectrum exhaustively, But if you do find yourself needing to understand how cumulative impacts should be assessed in relation to your project and whether there is any aspect of the assessment that could be deferred, then it might be a helpful passage to start with. On the facts in Pierce, the reasoning was that there's a set of principles set out in the Larkfleet decision that may allow a decision maker properly to defer assessment of cumulative impacts, even where they arise from the subsequent development of a separate site and they don't form part of the same project. And the example that's given and discussed in detail is Littlewood. In Littlewood, the conclusion reached was that it wasn't irrational not to assess cumulative impacts arising from future development of the remaining part of the site in that case, because the future development was inchoate, there hadn't been any proposals formulated, and there wasn't any or not adequate information on which actually a cumulative assessment could have been based. But Mr. Justice Holgate concludes in Pierce that the circumstances in relation to the Vanguard proposal were clearly distinguishable from Littlewood. He reasons that the two projects were closely linked. Site selection had been based on a strategy of co-location, and the second project had followed on from the Vanguard project after a relatively short interval. They were going to share a considerable amount of infrastructure with a common location, as I said, for the connection to the national grid at Necton. The DCO actually for the first project would authorise enabling works for the second. Importantly, when you're comparing Littlewood to the Vanguard case, proposals for the second project had been formulated in the Vanguard case. And as we saw at the start of discussion of this case, the promoter of the Vanguard project had put forward what it considered to be sufficient information on the second project to enable cumulative impacts to be assessed in the DCO decision on Vanguard, and that information had been before the Secretary of State. So for those reasons, Mr. Justice Holgate concluded that the failure to evaluate the information on the cumulative impacts of the substation development at Necton were a breach of the 2009 EIA infrastructure regulations. And you'll see that in his view, the only reason that the evaluation had been deferred was because the information in relation to the second development was limited. But in Mr. Justice Holgate's view, that's not the same thing as saying that you can't have a cumulative assessment or that the information in front of the decision maker is inadequate to do so. And he also points out that it would, of course, have been open to the Secretary of State to ask for more information to be required in order to achieve an assessment of the cumulative effects, but the Secretary of State hadn't done that either. Just rounding off the points that were made in Pierce, as well as being a breach of the EIA regulations, the deferral was, in Mr. Justice Holgate's view, irrational. And it also fell down because the Secretary of State's reasoning was extremely succinct. I think would be a fair description. You'll see that Mr. Justice Holgate says that a bare statement that the information on the second project was limited doesn't come anywhere near discharging the requirement to give adequate reasons in support of the approach taken. There was debate around whether or not relief should be withheld under Section 31 of the Senior Courts Act, and the Secretary of State did also make submissions on the importance of avoiding delay to an urgently needed project of national importance. But neither of those arguments persuaded Mr. Justice Holgate, and so the decision letter granting the DCO was quashed. Moving on then to the Abbott's Kurzweil case that Joel has introduced to us already this morning. I just want to look at ground one in relation to, again, greenhouse gas emissions and climate change from an EIA perspective in more detail. And one key point to take away from this decision relates to the standard of review. So you'll see that Mrs. Justice Lang notes that the role of the court in reviewing the adequacy of EIA environmental statements was reviewed by the Supreme Court in the Heathrow litigation on the airport's MPS, and she rejects an argument that the judgment of the Court of Appeal in the airport's MPS litigation establishes that there should be a more intensive standard of review where there's a patent defect in the assessment. The claimant had argued that was what you take essentially from the Court of Appeal's judgment in front of the airport's MPS case, and that although the Supreme Court reversed the Court of Appeal on the airport's MPS litigation, that aspect hadn't been disturbed. But Mrs. Justice Lang rejects that argument in Abbott's Kurzweil and says essentially there's not a separate category of unlawfulness based on a patent defect. So the adequacy of the environmental statement falls to be assessed according to conventional Wensby principles. The next couple of slides, I think Joel has amply covered just now about the application, excuse me. The judgment that's available to the Secretary of State informing a view as to the adequacy of an environmental statement. And we also saw, as Joel highlighted earlier, the significance that the local plan, the fact that the site in Abbott's Kurzweil was allocated in a local plan, meant that there had already been consideration of climate change issues at the earlier local planning stage, which is a factor that features quite heavily both in the in the Secretary of State's reasoning and then in Mrs. Justice Lang's reasoning. So her overall conclusion in Abbott's Kurzweil is that the Secretary of State had climate change issues well in mind. So the typical topics you'd expect to be covered really: the sustainability of the site, transport, flood risk, air quality and low emission strategy. So all topics that the application of planning policy requires to be dealt with, and she was satisfied that the Secretary of State's conclusion that he had enough information in front of him on climate change was a rational one. She also explained in Abbott Kurzweil that if there had been an error of law under Ground 1 on the greenhouse gas emissions, she would actually have declined to quash applying the test in simplex, because her view was that the decision would inevitably have been the same even if the legal error hadn't occurred. Moving on then, just briefly to two cases on SEA. The first is Rights Community Action, which is on appeal to the Court of Appeal, and I understand that judgment is awaited. So for that reason, I'm not going to spend very long on it at all, in case the reasoning that I'd be talking about is overturned fairly soon. But this was the judicial review that sought to quash the statutory instruments that introduced use class E and certain permitted development rights. So the amendments to the 2015 General Permitted Development Order and the 1987 Use Classes Order. The permitted development rights are the ones that allow for up to 2 additional stories to be constructed in certain circumstances, and also allow for demolition and rebuild for residential use in certain circumstances. And one of the arguments was that all 3 of these statutory instruments should have been subject to strategic environmental assessment. And there's a succinct summary at paragraph 79 of the judgment of the position under the SEA directive and the regulations. So essentially a plan or programme is only required to undergo SEA if all 4 of the requirements set out there are satisfied. And the divisional court focuses largely on the 3rd requirement, so the requirement that the plan or project must set the framework for future development consent of projects. It was common ground that 1 and 2 were satisfied, and for reasons that will be obvious in a moment, the 4th requirement didn't determine the outcome. So the claim was dismissed, and on the SEA ground of challenge, the divisional court concluded that none of the 3 statutory instruments constituted a plan or programme that set the framework for future development consents. The divisional court seems to have found the question perhaps slightly more obvious in relation to the use classes order than in relation to the 2 statutory instruments that amended the GPDO. It reasoned that a legal measure such as the 1987 use classes order that simply defines whether certain changes of use constitute development for the purposes of development control can't be described as setting a framework for the grant of future development consents, because by definition it does no such thing. But it then went on to reason on the 2 GPDO statutory instruments, and actually in relation to the GPDO itself, it would seem that doesn't set the framework for the grant of future development consents either, because it's the measure by which planning permission for defined developments is granted. But as I said, the Court of Appeal has now considered the SEA arguments, so we'll wait and see what it has to say about that. Finally, just to pick up the Friends of the Earth case in the Supreme Court, so the airport's MPS litigation, as Joel said, the Secretary of State for whom Andrew and I were acting didn't appeal the Court of Appeal, but Heathrow, who Richard was acting for, did. So there's a rejection, as Joel noted, by the Supreme Court of the Court of Appeal's position on the Paris Agreement. The Supreme Court decided that the Divisional Court had been right to reject the complaint that under the SEA directive, the Secretary of State for Transport should have made reference to the Paris Agreement. Just rounding off briefly with a few broader points on SEA that can be taken from the Supreme Court's judgment in Friends of the Earth. First of all, agreement from the Supreme Court that a defect in the adequacy of an environmental report prepared for the purposes of SEA may be cured by the production of supplementary material. There has to be consultation on that material, but there's emphasis several times in the judgment that SEA may properly involve an iterative process. So you can, of course, alter your draft plan, providing that you follow the procedural requirements for doing so. And then also, this is the passage that we've actually already seen Mrs. Justice Lang make reference to in Abbott's Kurzweil, but the passage around the standard of review. And essentially, there's no difference in the standard of review as between EIA and SEA. What's required is the Blewett approach, so conventional Wensbury irrationality standard of review. And finally, in this passage that I thought was quite interesting from later on in the judgment, where the Supreme Court it makes very clear that whoever is promulgating an environmental report under SEA should have significant editorial discretion and make sure that it's properly focused on the key environmental and other factors that might have a bearing on the proposed plan or project. And the Supreme Court was, it seems, quite worried actually about essentially environmental reports produced for SEA being far too long, not sufficiently relevant or focused, and you'll see at the bottom there, it was worried about the members of the public being drowned in unhelpful detail and losing sight of the wood for the trees. So, flipped on too quickly. To round up in terms of EIA and SEA, I think the themes are that climate change issues are coming, ever more obviously to the fore, but in response, the courts are being very careful not to trespass beyond their proper role. And also, as we can see from this final slide in relation to Friends of the Earth, careful to ensure that everyone remains focused on the purpose of both EIA and SEA, which is ultimately to enable members of the public to be properly informed about environmental impacts and not simply kind of drowning them in analysis and data. So thank you very much for listening in, and I'll hand over now to Andrew.
Thank you, Heather. Good morning, everybody. I think it's still just morning. So I'm speaking today on permitted development legal challenges. So the matters I'm going to be talking on today principally revolve around the Gluck case and the Smollis case, which, as Dan mentioned, I acted for Herefordshire Council in that case. And the matters I want to talk to you about revolving around the detail of some of the provisions in the order relate to, first of all, when and how may time be extended for the consideration of prior approval applications, and arising from the Smollis case, when may prior approval applications be refused for failure to meet definitional requirements, and I'll explain what I mean by that later on. What information should be provided by an applicant in support of an application, and what is the scope of any appeal against refusal where definitional requirements are in issue. And that's important because Smollis was a judicial review claim, but one of the issues was whether or not Mr. Smollis should have actually just launched an appeal to the Secretary of State through the normal mechanisms. So dealing first with Gluck, that was concerned with Article 7 of the order, and the particular provision of the order that was enforced to the 1st of August of last year, which has since been amended. And that essentially provides that where an application is made, which involves prior approval, the decision in relation to the application must be made by the authority, first of all, within the period specified in the relevant provision of Schedule 2, if there is one, that's paragraph A. Paragraph B, where no period is specified, there's a default 8-week period. And paragraph C provides effectively, or essentially, for such longer period as may be agreed by the applicant and the authority in writing. The amendment that came in after the 1st of August is that which is underlined. Within such period, such longer period then is referred to in paragraph A or B. So if you recall from the previous slide, A was if there's a period specified in the relevant provision of Schedule 2, B is the default 8-week period. So the amendment that has been made effectively clarified the first issue raised by Gluck, namely whether subparagraph C applied to both of the preceding subparagraphs. The claimant's argument was that where a period was specified in Schedule 2, such that the default 8-week period didn't apply, then it was not possible to extend time. Both the High Court and the Court of Appeal rejected that argument. The court said there were matters of both textual interpretation and common sense which supported extensions of time being able to be agreed. And I've spent some time just still talking about this reasoning because this theme of common sense is something that comes up in the smallest case as well. In relation to the textual points, that was just a straightforward point. If subparagraph C applied only to subparagraph B, these subparagraphs surely could and would have been combined. And the common sense point, which was quite powerful in my view, if an extension couldn't be agreed, even where both the developer and the local planning authority wanted to do so, for example, to allow the developer to supply further information or to hold discussions with the local planning authority or consultees, then of course that wouldn't be possible. And that does create a bit of a nonsense because it just divorces the order from the practical procedures and practical processes and common sense, what applicants and local authorities would like to happen. The second issue in Gluck was more difficult. That issue was what is necessary to show that a longer period is agreed by the applicant and the authority in writing. And the Court of Appeal split on this issue. And I'll deal with the respective judgments momentarily, but first the facts. On the 27th of April 2018, the applicant and the authority had a conversation over the telephone and they agreed orally that time should be extended for the prior approval decision to be made. The same day, the applicant's planning consultant wrote to confirm the oral agreement in an email, and the authority did write back, but didn't expressly confirm that agreement in response. They didn't say, yes, well, we accept that and we see what you said, we agree with you, and this is the terms of the agreement. Nothing that formal was set out. And on the 7th of May, after the initial time for determination had expired, the applicant's solicitors wrote to the authority, and I say here perhaps opportunistically, saying, well, since there was no expression of agreement to an extension of time, there was therefore no written agreement to extend time, and we have our prior approval. The local authority disagreed, and hence we had the challenge in Gluck. Mr. Justice Newey, Lord Justice Newey was in the minority. He held at paragraph 38 that there must be something in writing from both the applicant and the council confirming the agreement, even if the agreement was made orally. But both Lord Justices Hickenbottom and Henderson disagreed. They were keen, they said, to avoid unnecessary complication and to maintain planning as a flexible process without excessive rigidity or formula. And at 51 of the judgment, they said Article 7C requires no more than for the agreement to be evidenced in writing, and I would not be minded to put a gloss on it. Consequently, if, for example, an applicant and an authority orally agree to an extension, as they did here, and that agreement is acknowledged in writing by the applicant cannot then, in the absence of something in writing from the authority, say that the deemed planning permission had been granted under the order by the effluxion of the unextended period. So, in my view, a triumph of, I think, common sense, and as the court said, less formality in the process relating to permitted development rights. Turning then to the smallest case, two principal issues arose in the smallest case. The first was, upon receipt of an application for determination of whether prior approval is required, is it lawful? Is a local authority even allowed to determine whether the proposed development satisfies the definitional requirements of the permitted development class in issue? Or is the local authority limited to considering the prior approval issues? And the second issue was, did the council's decision that the definitional requirements were not met in that matter amount to an impermissible reversal of the burden of proof, and or had the applicant provided sufficient information in any event? And as I say, part of the council's response to the JR claim was that the claimant had an alternative remedy in the form of an appeal to the Secretary of State against the refusal of prior approval. PINS agreed, but the judicial review claim continued. And just to mention the facts, the application was for an agricultural building, on an agricultural unit. The local authority Herefordshire Council refused the application because it decided that the proposed building wasn't reasonably necessary for the purposes of agriculture within that unit. And they issued two decisions. The first decision was a decision which refused prior approval. So they went straight from saying, yes, prior approval is required, and to issuing a decision saying prior approval is refused. And they issued a second decision notice saying that planning permission was required for the development that was proposed. And it was those two decisions that was challenged in the Smoller's case. So what is meant by definitional requirements, or what at least do I mean by definitional requirements? Smoller's, as I say, was concerned with an application where the prior approval was required for a proposed agricultural building under Schedule 2, Part 6 of the order. Class A of Part 6 permits the erection of buildings which are reasonably necessary for the purposes of agriculture within that unit. That is the definitional requirement. And so a judgment is able to be made, well, the argument is that a judgment is able to be made whether what is proposed is reasonably necessary for the purposes of agriculture. Paragraph 8A2 provides for the conditions applicable to this class, and consistent with many of the condition provisions within the order, provides for prior approval, a prior approval condition, and states that before beginning development, an application must be made to the local authority for a determination as to whether prior approval will be required for the siting, design and external appearance of the building. So that's concerned with a different set of issues. Siting, design and external appearance of the building is different to whether or not the building is reasonably necessary for the purposes of agriculture. And as I say, the council refused the application not for the prior approval reasons, that is siting, design and external appearance, but instead because it wasn't satisfied that the particular building proposed was reasonably necessary for the purposes of agriculture. Effectively, the council's position was it didn't need to go on to consider siting, design and external appearance because it had resolved the anterior question against the applicant. The claimant's argument, quite simply, was that refusing prior approval on the basis that definitional requirements were not satisfied was outside the council's powers. If the council thought that the definitional requirements were not met, then it could express a view to that effect, but it could not refuse the prior approval application on that basis, effectively because the prior approval application was about those limited matters of design, siting and external appearance. If the council did express a view that the definitional requirements were not met, then the applicant, acting prudently, could seek a lawful development certificate to resolve that issue, or if the applicant just went ahead and constructed the proposed development or changed the use in accordance with the application and proceeded with the development, then the council could take enforcement action. So there was still remedies available to the council, albeit not the remedy of just simply refusing the prior approval application. And in making the argument that it did, the claimant relied upon the High Court's decision in Marshall, which sought in turn to apply the Court of Appeal's decision in Keenan. And I've provided the references for these in the first of my slides. Keenan was also about Part 6. This is the first in time decision. Keenan made it to the Court of Appeal. It was a decision of Lord Justice Lindblom. That was about a hardcore track. The local authority failed to make a determination in response to the prior notification application, meaning that prior approval was deemed to be granted. And the argument made by the claimant was that that meant he was authorised to build the hardcore track. So the definitional requirements, he said, were deemed also to be satisfied. The Court of Appeal rejected that argument. It held at paragraph 36 that the order doesn't confer upon the authority a power to grant planning permission for development outside the defined class. So even though you've got deemed prior approval, that doesn't mean that the implicit within that prior approval is a decision that you also fall within the definitional class of the particular class in the order that you relate to. Part of the court's reasoning in Keenan was that the provisions in the order relating to prior approval do not expressly or implicitly engage any other question, such as whether the development is reasonably necessary, respectively, for the purposes of agriculture within the agricultural unit. So the reasoning of the judgment does, on the face of it, start to blend together those definitional issues with the prior approval issues. But as we'll see, properly analysed, it wasn't doing that at all. Marshall was the next in-time decision. It was a decision of Mrs. Justice Lang in the High Court, which considered and applied Keenan. And the argument that was being made by the local planning authority in that case was that the effect of Keenan was that definitional requirements were outside the purview of the local authority upon a prior approval application being made. A local planning authority does not have power under the prior approval provisions, or indeed any other provision of the order, to determine whether or not the proposed development comes within the definitional requirements. And Mrs. Justice Lang accepted that argument, and that was the effect of the judgment in Marshall. And as I said, touched on previously, if a local authority thought the definitional requirements were not met, what was the remedy? Lawful development certificate or local authority taking enforcement action. And compared to simply refusing the prior approval application, these approaches involve obviously extra costs and resources and greater risk of unauthorised development taking place in the first place. New World Payphones is the next in time judgment, also a decision of the Court of Appeal. It didn't consider Marshall, but it did consider and apply Keenan. And in substance, the Payphones case confirmed that the statements in Keenan about the prior approval provisions do not expressly or implicitly engaging any other question were confined to the stage when an authority is actually considering the prior approval questions. So that posterior question, the question after the anterior question of whether the definitional requirements were satisfied. Remember that Keenan was a non-determination, so deemed approval case, and it said that Keenan didn't purport to decide whether the definitional requirements could never be considered when an application is made to a local authority. And at 49, Lord Justice Hickenbottom said in Keenan, Lord Justice Lindblom said that an application to a local planning authority for a determination would be as to whether its prior approval would be required, doesn't impose on the authority a duty to decide whether the proposed development is in fact permitted. But the thrust of that paragraph was that by requiring a developer to seek prior approval limited to restricted planning issues, that does not confer upon the authority a power to grant planning permission outside the defined class. On an application to an authority for a determination as to whether its prior approval is required, then the authority is bound to consider and determine whether the development otherwise falls within the definitional class. In Smoller's judgment was handed down on the 21st of June of this year, also a judgment of Mrs. Justice Lang, who was the judge in Marshall. And on issue 1, the claimant relied upon Keenan, the judgment in Marshall, and argued that New World's payphones could be distinguished. All these arguments were rejected and the court applied the payphones case. The net effect is the local authority is required to consider definitional requirements, much like in Gluck, in my view, the common sense of the outcome won through. The second issue in Smoller's about whether or not there'd been an impermissible reversal of the burden of proof really turned on the particular facts of the case. There are two matters to note. The first of those was that the application form used by the council was the standard form from the planning portal, which sought information on its face about whether the building was reasonably necessary. And the applicant sought to answer those questions, albeit briefly. And the second point is as I touched on before, PINS had confirmed that the whole dispute could have been resolved on an appeal, so the JR was effectively unnecessary. The final word on this, well, the Court of Appeal has refused permission to appeal. Lord Justice Coulson held that the court was bound by New World payphones, but anyway that the claimant's arguments were contrary to common sense, there would be no purpose in requiring a local planning authority to grant prior approval when that proposed development didn't meet definitional requirements. So that's where we stand on those aspects of the order. That concludes my talk. I'm very pleased to be handing over now to Richard to be talking about infrastructure matters and Planning Act 2008 challenges the last year. Thank you very much.
Good afternoon, everyone. Just going to take over control of the slides. So my talk is focusing on Planning Act 2008 challenges, and it's an interesting feature of this year of litigation in the High Court and in the appellate courts that so much of it has been taken up with Planning Act challenges. It's without doubt been a busy year, and as a result you've already heard about some of these cases in the context of some of the big ticket issues, namely climate change and EIA and SEA. In previous years we wouldn't have had much to say about Planning Act challenges, but in this year there is a lot. I'll come back to this at the end, but I just wonder whether it's right to say that the system is perhaps starting to be more exposed to challenge than it has been previously. I'll come on to explain that, but it's, I think, right to point out that for many years, we didn't have a single DCO being quashed. Many were granted, and we're now starting to see several DCOs being quashed by the courts. For many years, the MPS system was operating without challenge, and there's now been both a decision of the Court of Appeal that was subsequently overturned, quashing an MPS, but also a series of challenges and threatened challenges to other aspects of national infrastructure policy. So I'm going to split this into two parts. The first one is about policy making. The second is about individual decisions. In terms of policy making, the big case from the past year is the Friends of the Earth case in the Supreme Court, which we've already heard about both from Joel and from Heather. I'm also going to mention the Transport Action Network case, which is not concerned with a national policy statement, but with the road investment strategy. I've added there more in the pipeline. The reason I say that is that I'll come back to it, but there's obviously a lot happening in terms of national policy on major infrastructure projects, and there's also a lot of attention being given to how those matters are progressing alongside the UK's climate change obligations. So I'll just say a little bit about airports. You've already heard some points of detail both on the climate change elements and on the SEA elements of that case. I acted for Heathrow as junior to Michael Humphreys in that case in the Court of Appeal, there the Court of Appeal intervened and quashed the airport's MPS in respect of climate change matters, and those were grounds which in fact before the Divisional Court had been refused permission. So there was something of a surprise about the change in position. I think the one thing I would say about the Heathrow case, as often happens in these cases which have profile, people lose sight of the fact that they often just turn on their particular facts. And the central issue there was a question of public law and a question of the application of public law to the facts of the case. The Court of Appeal proceeded on the basis that the Secretary of State had ignored the Paris Agreement in deciding to designate the airport's national policy statement, and indeed appeared to find that the Secretary of State had done so on the basis of legal advice that the Paris Agreement was legally irrelevant to his determination as to whether or not to designate the MPS. In fact, the Supreme Court found that that was not what had happened. What had happened was the Secretary of State had concluded that the Paris Agreement didn't change matters for a series of rational reasons. And once those facts were resolved in favour of the Secretary of State, the rest of the case really fell into line. And there isn't quite the sort of novel propositions of law that some people might suggest in that case. And we've already seen this from Joel's helpful slides, but there is a finding that government policy on climate change, which is something that has to be taken into account in designating a national policy statement, is found in formal statements of policies and not in a trawl of Hansard, nor is it found in the ratification of government policy for the purposes of the ratification of the Paris Agreement for the purposes of establishing what is government policy. The next point was about the Section 10 duty, which is that the Secretary of State must make national policy statements with the objective of contributing to the achievement of sustainable development. And that in itself didn't make the Paris Agreement a mandatory material consideration. It's something that the Secretary of State could take into account, but could conclude that it didn't change his reasoning. And the same is true of the analysis under the SEA directive, as Heather has explained. So in terms of the consequences, well, you've seen through Joel's talk how Heathrow has been relied on and applied in subsequent cases. And I think it's fair to say that it has somewhat narrowed the circumstances in which a DCO or an MPS or other matters of policy or indeed individual decisions can be challenged on the basis of climate change matters. For the MPS regime itself, more specifically, my conclusion is that it affirms a relatively broad discretion on these matters. Compliance with the law is assessed on normal public law principles. And it's also worth noting that the request for a review of the airport's national policy statement in light of Paris and in light of the new targets in the Climate Change Act 2008 was refused by the Secretary of State. And as I understand it, that decision has not, in fact, been challenged. But there's no doubt more to come on airports, including the Jet Zero decision making, which is about how does the aviation industry get towards contributing to the net zero target, and the consultation on that concluded in September. I'm going to talk then about Transport Action Network quite briefly. This was a case that wasn't a challenge to a national policy statement, but to the road investment strategy number 2. And we'll see, in fact, briefly in the Stonehenge case, that road investment strategy is quite important because it sets out the schemes that are going to be supported by funding for major road investments. And the RIS is set pursuant to a statutory duty in the Infrastructure Act 2015, which includes a duty to consider the effect on the environment. And Transport Action Network challenged RIS 2 on the basis of, amongst other things, the way in which it considered climate change obligations. And the court found the Paris Agreement was not a mandatory material consideration for these purposes. And it was a matter of judgment as to how far to consider the environmental consequences of road investment. And this road investment strategy was not the place to consider the overall effect of the strategic road network on climate change. So what next for policy? I just note, of course, that obviously there's emerging policies, in particularly the energy NPS suite, which is going to be particularly important for setting our route towards net zero. There was a threat of challenge against the failure to review the energy suite, which went away when the consultation was launched on the review. And clearly sort of both sides of the equation are potentially risks for challenge in the future. And I think that the advice of the CCC and of course the Climate Change Act targets and budgets are likely to be more important for the purposes of future challenges than international agreements, whether the Paris Agreement or, fingers crossed, perhaps the Glasgow Agreement. But it's the domestic implementation of those that's more likely to drive change and challenge, and successful challenge at least, in domestic policies, because of the approach of the Supreme Court to the Paris Agreement in Heathrow. So I'm going to quickly go on to DCO challenges. And there's been a rush of decisions, as I've already said, after many years of not having a single DCO be quashed. There was a successful challenge to a refusal of a DCO some years ago, but for many years there was no successful challenge to the grant of DCO. And worth mentioning, I think, 3 cases, and I'll just mention Manston in passing. That was quashed by consent, essentially on a reasons ground, although the challenge was rather broader than that, and that's now in the redetermination. Norfolk Vanguard, that's the Pierce case, which Heather's already spoken to briefly, and the A303 Stonehenge case. They were both decisions where the DCO was quashed following a contested hearing. Just say a little bit about both. and Heather's really covered Pierce in more detail than I do here, but as she explained, Vanguard was proposed to share onshore infrastructure with the Byass scheme. There was an application in the process for Byass, so it wasn't sort of an unknown future scheme. It was one where there was an application, and the Secretary of State decided that the information that he had about Byass was limited, and therefore he could leave consideration of Byass impacts at the onshore substation site for later determination, and didn't have to deal with them as cumulative effects in determining the Vanguard application. And as Heather explained, that was found to be a breach of the EIA regulations. It was irrational not to consider the cumulative effects of Byass with Vanguard, and the reasons given were legally inadequate. And I think this flags the sort of main issue which has arisen, which is departing from recommendations of the examining authority and the strength of the evidence on which that is done. That leads to Stonehenge. Now, Stonehenge is a monster judgment, obviously a major scheme of very high profile, and essentially the claimants were concerned with the heritage impacts of the scheme, which, whilst removing the road from parts of the immediate setting of Stonehenge, involves a very significant tunnel proposal, which itself has impacts on heritage assets. The grounds were many and varied, but the adverse findings are worth focusing on. The court found the Secretary of State had failed to take into account the effect of the proposal on all heritage assets in departing from the examining authority's recommendation. Now, this is a bit of a tricky one for Secretary of State if he or she is proposing to depart from an examining authority's recommendation on a point of where there might be a lot of detail. In this case, there were a whole range of heritage assets that were affected, and those effects were described in the environmental statement. They were summarised in the examining authority's report, but the examining authority's recommendation was that what they saw was substantial harm to heritage assets, and including those with the highest status as World Heritage Sites. And the conclusion was that on that basis, the proposal should not be granted development consent. Secretary of State disagreed, set the level of harm lower, i.e. high end of less than substantial, and in doing so, didn't undertake a full analysis of each of those assets which were subject to an adverse effect. And the court found that that in itself was unlawful. If the Secretary of State was going to disagree on the overall recommendation in respect of level of harm to heritage assets, he had to do so on the basis of an articulation of the impact on each of them. And it shows that perhaps the sort of normal, relatively light touch decision letters, when they're read compared to an examining authority's report, is quite difficult when you have a disagreement on a point such as this, because what's really required, I think, to address the sort of concerns that were identified in Stonehenge is a much more thorough consideration of each of the impacts. The second ground is perhaps a more substantive point of interest for others, and that's the approach to alternatives. This is the second successful ground. There were various others that failed. The Secretary of State was found to have failed to consider all alternatives, having taken an unlawfully narrow view of the scope for alternatives. He relied effectively on those schemes which had been considered by the applicant, put into a relatively narrow group of considerations, and those alternatives which have been considered through the decision-making process if it got to the 303 proposals in this location. And that was found to be unlawful. There needed to be a more thorough consideration in light of the harm to the World Heritage Site. So that's a point of more general application, I think, where it's considered that there is a particular impact that generates the need for consideration of alternatives. That's a substantive complaint, a matter of ordinary planning law principles. It's a substantive complaint, and you don't need to get into this. What did the applicant consider for the purposes of EIA adequacy? You need to consider whether there are alternatives that could avoid the harm, and that may go beyond those which have been articulated in ES and so on. Those are sort of the cases where the Secretary of States have fallen into difficulties, but it's not all bad news. And we've already heard about the Client Earth case on the Drax repowering, which Joel covered. The only other case that I was going to mention is the EFW group case. In that case, there was a split decision on proposals which slightly complex, but they included a new energy from waste facility and changes to an existing facility. The changes to the existing facility exceeded the threshold in the Planning Act 2008 and were subject to the energy national policy statements. The new energy from waste facility did not fall within the Planning Act 2008 thresholds and was not the subject of national policy statement as a result. But there was a Section 35 direction, which is a direction meaning that they were treated as a national policy, as a nationally significant infrastructure project for the purposes of coming within the Planning Act 2008. And the complaint, or the major complaint in respect of the decision, was that the designated, the Section 35 project, was refused. And it had been refused on the basis of a misdirection in respect of the approach to the decision-making principles in Section 104 and Section 105 of the Planning Act 2008. Section 104 is concerned with cases where there is a national policy statement in force. Section 105 with decision-making where there is no national policy statement in force for the development of the type concerned. And the court found that in circumstances such as this, the proper approach is that the element which is subject to the national policy statement should be dealt with under Section 104, and the element which is not the subject of national policy statement should be dealt with under 105. And the Secretary of State was wrong in his approach to treating them both as dealt with by Section 104. However, in substance, it didn't make a difference because the second project, the Section 35 element, had been refused on clear planning grounds, and accordingly it would have been refused on those grounds even if the Secretary of State had followed the correct decision-making tree, namely following Section 105 rather than Section 104. So the challenge to the refusal there failed, and the decision of the Secretary of State was upheld. So conclusions. I think it's clear to me that there's a very important risk here for decision making, and that is where the Secretary of State is departing from conclusions made by examining authorities. These are cases which are prone to complexity. Those involved in the examination processes know how heavy those processes can be, and if the Secretary of State is seeking to disagree, it may be difficult to articulate that disagreement with sufficient detail to overcome the recommendation, particularly when that detail is simply not available. And I think that really is the key risk for DCO challenges. And you can couple that, I think, with examination processes and the stress and workload of those processes, which I think increase the risk of matters being forgotten about or errors creeping in. So then just something on the likelihood of further challenges. Well, what we've seen over the past few years is an enthusiasm, I think, from all sides to think about challenging these decisions. Having not seen any successful challenges to DCOs, we then get a rush of them. And in my view, those sorts of circumstances point to perhaps more enthusiasm to future challenge. So I think watch this space, and we may see more in the coming years. I'll hand back to Dan now. Thank you.
Thank you very much, Richard, and to all of our speakers. Could I ask all the speakers, please, to put their cameras on and be ready to unmute as appropriate. We've now got a short amount of time for questions. We've had a few submitted already and we'll pick those up. But could I just sort of say last orders, please, if anybody would still like to ask a question, could you put it in the Q&A now and we'll do our best to pick up on it. So there is, just to start, there was a question asked that I think has been answered actually about Finch in the Court of Appeal. So our understanding is that Finch is going to the Court of Appeal, and the hearing is on Tuesday and Wednesday of next week. So there could be some ongoing developments in relation to that. We have actually, Finch has actually been the topic that's probably provoked the most questions. So or the case that's provoked the most questions. So I think in the first instance, can I just direct a couple of points on Finch to Heather? So, so Angus Walker is asking a question really about how distinct you think the distinction in Finch is in terms of ruling out the indirect effects as not relating to the development. How sort of sustainable is that line, and how does it compare, for example, to, if you like, the indirect effects of a road project that would be assessed as part of the EIA assessment? Heather, did you have any thoughts in relation to that point?
Yeah, I'm only smiling because I think it's really difficult, and I've been trying to kind of work out what I think the distinction is myself over the weekend, and I haven't got an easy answer. I mean, I think possibly the strongest point of distinction is the one that Mr. Justice Holgate makes in the judgment at paragraph 101, which is where he essentially makes the point that in Finch, the ultimate consumption or the end use comes after there's been an intervention really from a number of other developments and projects that intervene between, you know, the site in Finch where the oil was being extracted and then the ultimate burning of the fuel in motor vehicle engines. Whereas I suppose on a road scheme, the emissions are generated on the road itself. But then again, I'm sure the claimant in Finch would say, but they're only generated because someone has produced a vehicle, you know, off-site that then enables the emissions to be generated. And all of us will have come across applications for big residential schemes where one of the things we argue about is, I don't know, air quality impacts from vehicles being driven by residents, but off-site, obviously. I mean, looking also at paragraph 126 of the judgment, as well as the point about interventions from separate facilities and developments, Mr. Justice Holgate also is concerned that the location of the ultimate consumption or use of the end product is unknown. So there's that point as well, which might be a kind of brighter line of distinction. But honestly, I mean, having thought about it whilst Richard and Andrew were talking, I wonder if it's as simple as, you'll recall I mentioned that Mr. Justice Holgate said that a local planning authority obviously has to apply existing policy on climate change and greenhouse gases, but doesn't additionally have to go on and then assess those through EIA. I wonder if the distinction is as uncomplicated as the fact that, you know, you have to do what existing policy requires you to do, and it says what it says about road schemes, and it doesn't at the moment require an applicant for oil extraction to, you know, assess the entirety of greenhouse gases right through to the end product. But I think it's difficult, and I'm glad I'm not the Court of Appeal, because someone's going to tell me what the answer is now, but I can't immediately see where the sort of bright line distinction is myself.
Yeah, well, it sounds as if Finch in the Court of Appeal might be something to watch with interest to see whether there's any greater clarity as to what the practical implications of that are. I think still on EIA, and so this might be for Heather, but I'm happy for anybody else to pick this up, so that there's a couple of questions that I'll sort of take together and just invite any comments on them. So one of them is well, it's expressed as a comment rather than a question, but I would be interested in any views from the panel on it in terms of whether the paragraphs 91 to 94 of Finch, where there's a sort of literal interpretation about an EIS has to be only based on a scoping opinion, whether that's, if you like, loosening the obligation, or whether that's just a sort of that it's always been so, and that's just it's expressed in that way. And I think related to that, the extract from the Supreme Court's reasoning about drowning in unhelpful detail, I think strikes a chord with a great many people, and a question has been framed in terms of that, as to, you know, whether that will, you know, obviously it's not just the members of the public who are drowned in that detail, it's also potentially hard-worked planning officers. Do you think that might be a catalyst for a change of practice and a change of emphasis in terms of really honing in the environmental effects and being less defensive, or do you not see any changes? So I mean, Heather, it's kind of your topic, but I don't know if, I mean, Richard or Andrew, Joel, if anybody wants to pick up on that or any of those themes.
If I just I'll shut up and let everyone else have a go in a minute, but if I just come back on the scoping opinion and the sort of based on the scoping opinion requirement, yeah, I agree completely that the sort of take on that comes from Finch isn't particularly rigorous, but Mr. Justice Holgate gets to his conclusion from an analysis of the wording of the regulations that seems to me, on an initial view anyway, to be correct, because he points out that there's a distinction between the terminology of it being based on the scoping opinion as compared to obligations elsewhere in the regs that sort of actually require you to include certain categories of information. But I think the important point to draw out is paragraph 94, where he highlights that if actually the environmental statement doesn't provide the details that the local planning authority was expecting in the scoping opinion, then under regulation 25, the authority can actually require additional information to be provided. So he seems to be reasoning that, you know, based on isn't the most demanding requirement, but there is a kind of fallback mechanism whereby the authority can get the information it wants if the environmental statement has wandered too far astray from the scoping opinion. But I do suspect this might not be the last we've heard about what based on means. Yeah. And does anyone want to come in on the other point about the potential change of practice? Richard, any thoughts on that?
I mean, I think the Supreme Court were pretty horrified about the amount of documentation that they saw, and then I think they were told at some point that, you know, what they were looking at was the tip of an iceberg in terms of the environmental assessment that had been carried out for the airport's NPS. But as ever, it's sort of easy for the appellate court to say this all looks like far too much detail without, you know, perhaps telling us what needs to be cut down and how we can make these processes more efficient. And, you know, you take a case like Pierce, and the Secretary of State saying, well, I'm going to leave that particular consideration to deal with it on the Byass scheme and not worry about it for Vanguard, and the decision's quashed because he didn't take it into account. So I think we're stuck with volume of environmental statement. You can't scope in significant effects and then sort of cut down your analysis, really. I think we can all work to use fewer words and fewer pages, but I think once you've scoped something in, you've got to deliver a proper assessment within that. Otherwise, the decision maker should ask for more information, and B, if they don't, they're starting to run the risk of challenge that they haven't taken into account the full environmental information.
Yeah, thank you very much. And then just perhaps one last question, just picking up based on one that's been submitted in the last few minutes. And Joel, this is one for you, but others might want to come in on it. But thinking sort of perhaps more broadly about climate change issues and whether, sort of absent the statutory framework, there's climate change as a material consideration in planning decisions. And in particular, one point that's highlighted is that many boroughs have obviously made their own declarations of climate emergency. Now, what the status of that is as an enhanced consideration is a moot point. But do you have any thoughts on how that might feature in terms of potential challenges, or how that should be played in planning decision making at local level?
It's interesting whenever these types of advices come through, and I'm asked to to think about whether or not there is the scope for a climate change ground. Initially, one of the first things I tried to look for is, well, has there been a climate change emergency declared in this area? And often, unfortunately, recently, most of my advice have tended to go, well, we don't have enough here to actually raise the ground. But I think what we know is there's still no authority on this particular that states that climate change is necessarily a material planning consideration. Or I think it might be the scope for claiming that it's not necessarily a material planning consideration in an appropriate case probably now seems somewhat more limited. And I think particularly in circumstances where you do have a local authority with a climate change emergency, I think it'll be very difficult to argue in that direction. But even with that, I mean, having gone through the authorities, if we are able to find a case that shows that it is a material planning consideration, we still don't have any real authority on what the scope of that consideration should look like. And we've seen just the amount of deference really that's given to decision makers and second state and local planning authorities in determining really how to approach this particular question. Now, I think my expectation will be that we should expect to see a challenge coming up soon, a climate change challenge that settles this question. I think we will get one that will succeed in the very near future. But I think all of us here are still really waiting out for the appropriate case. Thank you.
Andrew, did you want to come in?
Yeah, it's interesting. One of the issues in the challenge to RIS2, which I acted in for the Department for Transport, was whether or not the impact of the RIS2, which was a £27 billion infrastructure scheme, whether or not actually the climate change impacts of that were de minimis as compared to the climate change considerations in issue in that case, which was the Paris Agreement, the carbon budgets, etc. And it was part of the Abbott findings of Mr. Justice Holgate, but he did find that they were de minimis because the carbon impacts of even that £27 billion infrastructure development were so small compared to the total carbon output of the whole of the country. So if you take that down to a local level, you can see where the arguments might go. There is authority, of course, that where decision makers have taken into account climate change matters and prayed those in aid in order to say, well, that's a material consideration. And because this didn't take account of this climate change concern, I'm going to, as an inspector, I'm going to refuse planning permission. But that's very much an inspector in his discretion, or a local authority potentially in their discretion, looking at this, as opposed to that consideration being obviously material and being a mandatory consideration. And in the absence, in that sort of framework which we're acting in, I think it's really going to be for policymakers and decision makers to, positively try to take these matters into account and positively incorporate them into policy going forward.
Thank you. Thank you very much. I think we've probably reached the limit of the grace period after the scheduled closure time. So I'm going to draw matters to a close there. I'd like to thank our speakers very much indeed for expertly navigating us through the choppy waters of legal developments in the High Court planning cases and avoiding us being drowned in unhelpful detail as we go. Thank you very much indeed. I'd like to remind people that this is but the first of three, so same time next week and same time the week after for the second and third instalments of the High Court planning webinar. I'd like to thank each of you very much indeed for attending, and I hope you've got as much out of hearing the talks as I have. Thank you all very much indeed, and good afternoon.